would agree under both the statute and PALMA, we're not entitled to fees for time spent litigating the amount of fees. I'm into my rebuttal time. I'm happy to answer questions or reserve the balance.
Pleases the court. Bill Bissett, representing the Florida Insurance Guarantee Association. Did have some points to cover, but I'd like to try to discuss some of the questions that have been asked and how.
Has FIGA always taken the position that any attorney's fees, even if, say, in this case, the judgment had already been entered for the amount of attorney's fees, is not within the coverage of the FIGA statute? That's been, does it matter at what phase of the proceeding the attorney's fee claim is?
Does it make a difference? 631.70 is right on point. So
you would not rely on, that's what I see, I'm relying on the covered claim portion, but you actually are saying that we could first decide it just under 0.70, being that is a separate reason for upholding the second district's decision?
Correct, Your Honor.
How will you distinguish
and there's
Palma? How will you distinguish Palma from this case?
Palma, actually, the only portion of that decision that's relevant is about one sentence, which states that 627.428 is an implicit part that's read into a policy. In effect, what the court was saying, that under that statute, when a dispute arises between an insured and insurance company over either a delay in resolving the case or resolving the claim, or in outright refusing coverage, and a lawsuit has to be filed to attempt to obtain the benefits, the coverage under the policy, then that statute declares that the insured will be able to recover reasonable attorney's fees. It's part of the policy that the Florida legislature, it's a statutory obligation that's been determined repeatedly in the nature of, or to actually be a penalty, which is a separate argument.
Why isn't a reasonable reading of 631.70 really is that you cannot get attorney's fees for your dealings with FIGA unless, let's see, unless they're doing something that's delaying it and unreasonably, or because I don't read that. I quite frankly, I don't read that as saying that FIGA is not going to have to pay attorney's fees that have already been determined. That just they were not liable for attorney's fees in your interaction with FIGA, unless FIGA is having some unreasonable delay.
Well, I think the key word in that sentence is the provisions of 627.428, which their entire claim is predicated upon, provides that attorney's fees shall not be applicable to any claim. Any claim. It doesn't say pre-insolvency versus post-insolvency, and the word "any" has broad, all-inclusive meaning, and you would have to ignore that word.
Any claim that is brought to FIGA. As opposed to any claim that has already been litigated. I mean, it seems to me that is just a reasonable reading of that as your reading of it.
What would make it, from a policy standpoint, unreasonable is that if it only applied to post-insolvency, things that FIGA can control, but leaves open this wide door for the assessment of attorney's fees based upon the failure of the insolvent insurer to properly handle the claim and to pass that enormous amount of attorney's fees, typically way beyond what the value of the claim was.
So but you do agree that there's two aspects to liability policies, correct? You've been doing this for a lot of years, right?
A lot of years, yes, Your Honor.
Okay, so there's two different things: duty to defend.
The duty to defend.
And duty to pay the claim.
Correct.
If they don't defend in the liability context, you're saying that the FIGA statute has no responsibility for that, even though the policy covers the defense?
No, and Jones held that that's a contractual obligation that's within the coverage.
Within the coverage, so you should have to pay those fees.
That
So what you're
definition of
saying,
covered claim.
what you're talking about is first-party claims where there's a denial of coverage and you have to sue your own insurance company, not for defense of the claim, but for the benefits.
Correct. And the legislative history bears that out. It basically said, this was back in 1977, that FIGA was automatically being held responsible for these fees and people were seeking to recover them. And the legislature wanted to limit the recoverability of fees based upon the actions, affirmative actions of FIGA itself.
Let's go, okay, so in this situation though, if 627.428 applies to FIGA, but only if it says deny by affirmative action. What does that mean?
If they deny a claim, there have been several recent decisions. I think we may have cited one.
Well, isn't this the claim that was presented to FIGA was the claim for the attorney's fees that had been previously incurred? And they denied it and said it wasn't within the scope of their obligation, correct?
Correct.
So if the decision in this case is that it is within the scope, then you'd be responsible for additional attorney's fees, wouldn't you?
If it was in the scope of the
Right,
policy,
so I'm not
then
sympathetic.
they're not relying upon 627.428. If it's within the coverage of the policy, we're obligated because of the definition of
I'm
covered
just not
claim.
seeing, and I understand others may have different views, that 637.70 gets you there. So let me go back to the one that I think is either the stronger argument, and you tell me if it's plain language or it's ambiguous about that this is, whether this is a covered claim or not, that is, the prior claim for attorney's fees.
First, we believe that the term that's used in the statute, the three elements of a covered claim means unpaid claim. It arises out of the insurance policy. It's within the coverage of, and in this case, that's the key.
Well, it is
and it's not
okay, but see, here's the problem. It is within the coverage because just like Justice Lewis was saying, the coverage could be, you know, that it's somebody, it's a defense lawyer that was defending the insurance company and they're supposed to get paid. Can they get, and they are asking for fees not under 428, but they didn't get paid. Can they will FIGA pay for the defense lawyer who didn't get paid by the insolvent insurer?
Well, they would not have the defense lawyer that didn't get paid would be a class, as I understand it, under the receivership statute, it would be a class 6 because he's not, there's no contract between the insurance company and with respect, the contract that's being breached is not the insurance contract, but the employment contract between the insurance company
so it's not
and the insolvent insurer.
Then that would not be a covered claim.
That's slightly different. But
Is
if
that
the
correct?
insurer,
That's not
correct,
a covered claim?
Correct, that's not a covered claim.
So how do you then, and again, maybe it's an inartful drafting, including one of unearned premiums, if that was not in there, including one of unearned premiums, would unearned premiums be a covered claim?
Unearned premiums are a covered claim, whether they are specifically included in the policy.
Well, how does it arise out of and is within the coverage of the policy?
From the
Isn't a premium separate? It's what gets you the policy. It
correct.
doesn't arise of and within. It's not within the coverage of the
correct.
policy.
It's not going to meet those three elements. And I agree, it's somewhat awkwardly worded. What's between the two commas? If you were dealing with grammar, probably could have been put at the very end of that sentence.
Doesn't that create a problem, though, for the drafting of this because it wasn't placed where it was, that whether including one of broadens the term covered claim. And I'm more sympathetic to your statutory construction argument, but I'm struggling, and so I want to understand somehow that throwing that one of unearned premiums in, I'm not sure if that helps or hurts FICA.
Why that was important is because it's not included in that specific remedy is usually a statutory remedy where unearned premiums have to be given back. It's added in there because under the liquidation orders, and which are pursuant to the receiver statute, these policies within 30 days of the declaration of insolvency, all of the insolvent insurer's policies are, if not sooner canceled by the insured, are going to be canceled, and replacement coverage has to be located. The statute and the legislature wanted to make sure, as they do across the country, that that money goes back, that's left on that policy, the unearned premium goes back to the insured, and they didn't want a situation where, since it's not technically within the coverage of a policy, that unearned premium would not classify as a covered claim. That's why it's thrown in, to make it clear. And whether it mentions it in the policy or whether it's by a statute which requires that, it's going to be considered a covered claim and it would be paid. And that's as consistent because that assists the unfortunate insured in securing additional coverage to carry out the remainder of the term. And I think where we started, it's I was listening to the previous argument, and we're dealing basically with plain, unambiguous language. So I agree, it was a very interesting brief, through in a lot of different twists and turns, but in reality, this is a very straightforward case. Separate and apart from, as we've discussed, 631.70, it's the question of, do the attorney's fees under 627.428, are they within the coverage of this policy? They concede it was not. 627 doesn't make attorney's fees coverage or benefits under that policy, like, for example, the UN example. FIGA would have, that's going to change the coverage of a policy. If the insolvent insurer's policy doesn't comply with the PIP statute, the UM statute, that policy, by one of the statutes they cited, is going to be reformed, and it will be read as if it includes within the coverage that statutory mandated coverage. There's nothing you'll find in 627.428 that says the policy has to be amended so that it provides coverage for attorney's fees. And I can't make it really any simpler than that. And the legislature has spoken, and from a policy standpoint, if you increase the operating expenses, then the only people that are ultimately going to bear the burden of that are the Florida citizens and businesses that purchase insurance, because assessments will go right through the insurance company, and by statute they can pass those on to the consuming public. And we would request that this court approve the decision of the second DCA in this case. Thank you.
I want to focus on the 631.54 covered claim definition. First, it's ambiguous. They just said that unearned premiums aren't within the coverage, but yet they're covered claims. If you read the plain language of the statute, the which clause modifies unpaid claim and unearned premium. So if an unearned premium doesn't arise out of and is within the coverage, it can't qualify. Second, I've heard analogies to the liability cases. I'd like to point the court to an analogy to workers' comp cases. Since 1980, Florida courts have held that worker comp fees are covered claims under 631.543. And that's a much closer analysis to this, because there the worker is adverse to the carrier. You can sue the carrier in workers' comp. It's like first party. And under 440.34, whether or not the policy says it or not, if the worker wins, he gets his fees. And since 1980, three district courts of appeal have held that workers' comp fees are a covered claim if incurred pre-insolvency. And the legislature has done nothing to change that. And the sky has not fallen, even though workers' comp fees are a covered claim. And to address sort of the policy argument here, what they're asking you to do is, you're right, FIGA ensures that whenever we have an insolvent company, that the risk of that insolvency is spread through everyone in the state. It goes through FIGA, then they assess the insurance companies, and then they turn around and certainly assess their policyholders. If you didn't have that, the risk would be borne only by the policyholders of the particular insurance company. The few insureds in the state would bear all the risk. And if you read, I'd encourage you to read the Sturdivant amicus brief. It explains how if you don't allow these fees to be covered claims, it means that homeowners whose homes are lost in hurricanes are not going to be able to rebuild their homes because the attorneys are not bearing the risk here. The attorneys are going to get paid one way or the other. They're going to get paid on a contingent basis or from FIGA. And if the attorneys have to get paid on a contingent basis, the homeowner's not going to have enough money to rebuild their home or whatever other loss they may have had. So I would ask the court, based on the arguments presented in the brief, to reverse the decision of the Second District Court of Appeal, find that a claim for pre-insolvency fees is a covered claim and not barred by 631.70.
We thank you both for your argument. That's the final case on today's docket. The court will now stand adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.